I do not know the actual answer, but I'm like reading how the way they set this up and the way they've trained the officers. I am almost certain that it's a response to Rodriguez. We can't extend the stop, so we just need to get consent. You get consent by doing the little shimmy and a shuffle back, and then saying, "Hey, I got one more question for you."
Right. And often during the shimmy itself may be a way to just keep the stop going, but it may be a way to buy time for the car with the canine to get there. So then they can have the dog go around and do whatever it does, and then supposedly have probable cause for the actual search. Like
Yeah.
that's how they often piece it together. You've all heard of the Texas two-step, but there's a lot of other two-steps, both in dance and in law. For a long time, there was the Chevron two-step in administrative law, and there's still the reasonable expectation of privacy two-step in Fourth Amendment cases. There's also the qualified immunity two-step, which we've discussed on this show way too many times. But have you heard of the Kansas two-step? It's a neat little practice of the police officers in the state of Kansas. But is it constitutional? We'll discuss that this week, plus knives in California and a little dive into the Second Circuit here on Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, director of the Center for Judicial Engagement at the Institute for Justice. We are recording this on Tuesday, February 10th, 2026, and I have two of my Institute for Justice colleagues with me to discuss these cases from the 10th Circuit about the Kansas two-step and the 9th Circuit about the state of California's regulation of switchblades. So all you switchblades fans out there, please stay tuned. Then at the end of the show, we will continue our series of 12 months, 12 circuits. This is the second time, so of course it's the Second Circuit. That is the Federal Court of Appeals, the branch of the Federal Court of Appeals that covers the state of New York, Connecticut, and the state of Vermont. So all you Second Circuit fans, you can just skip through to the end for that little bit. But for those who enjoy dancing, and maybe also Fourth Amendment violations and switchblades, you will like the middle of the show. And so to get there, I first want to bring on Nick DeBenedetto. He is a colleague of mine here at IJ. He's been on the show before, and so we're happy to have him back. And a little later in the show, discuss this latest Second Amendment case. So unlike most Second Amendment cases that we're all familiar with, this is not about guns. It is about knives, about switchblades. So I myself, and I suspect most listeners, have never owned a switchblade. But I am old enough, so maybe we'll get into a little generational difference here. I am old enough that when I was a kid, just about every boy wanted to have a pocket knife. And, the cooler pocket knives were the ones with more stuff. So the really lame ones were like just had a knife and maybe a bottle opener, right? But then you get the ones with the big knife, the little knife. There was the corkscrew bottle opener. There would be something that was usually described as the thing that you use to get rocks out of horses' hooves. I remember that was often the description. I don't know if I ever had one of those. So, Nick, I am curious. You're a little younger than me. Are pocket knives still a thing for boys? And do they still want the thing that gets rocks out of horses' hooves?
Well, it's great to be back, Anthony. Thanks for having me. And I would say, yeah, pocket knives remain cool. When I was younger, I had a small collection of pocket knives that started with a Swiss Army knife that my uncle bought for me on a family vacation up to Vermont. Can't say that it got a lot of use over the years, but it was a neat thing to have. And I'm unfamiliar with tools to remove rocks from horses' hooves, but I would say the most interesting tool that I've ever used or came near occasion to having to use on a pocket knife was a glass punch from my days as an EMT. You could break glass windows with a little nub on the end of the pocket knife if you needed to extricate someone who was trapped inside of a car.
Oh, right. Yeah. Okay. I've seen, sometimes people have those in their cars. They're not even with knives. Having it all with the other knives sounds very handy. Well, that's great to hear. Pocket knives are still a thing, or they haven't been banned quite yet.
Not
Although
yet.
I'm sure some people are moving in that direction. But one thing that also is not banned is or is it? Is the Kansas two-step. So Jared, he's going to share with us this case from the 10th Circuit that Jared McClain, I should say, our IJ colleague, who this case is about something it seems like police officers in Kansas know they're not supposed to do, but it's really hard to get them to stop doing it because it's hard to define exactly what's wrong about it. And there's a bunch of other kind of wrong stuff in this case as well. So Jared, tell us what's going on.
Yeah, this case is a pretty good example of how hard it is to get the police to stop doing anything in the courts. The case name is Shaw versus Smith out of the 10th Circuit. It was issued January 29th, and this case was brought by the ACLU years ago and went through 3 trials. It's an incredible, factual record about this practice that Kansas Highway Patrol put into place after Colorado legalized cannabis, and the Colorado and Kansas border one another, and the Kansas Highway Patrol thought lots of people drive on our highways, lots of people come and go from Colorado, and those people probably got weed in their car, and we should find out. And the way that they decided to do this was a two-step process that is separate from the two-step itself. So
A lot of two steps.
a lot of two steps in this case. And so the first thing that they were doing was targeting people who had out-of-state tags. So people who were driving through Kansas and it looked like maybe they were coming on the highways that you would use to get to Colorado or from Colorado. And if they had out-of-state tags, they were basically treating that as reasonable suspicion to pull the car over. These out-of-staters are suspicious. They might be near Colorado. They probably got weed in their car. And they...
Why else would you go to Kansas?
Yeah, no, exactly.
That
seems
to be.
That seems, yeah. And... yeah, so they've admitted that they're stopping these cars because of their out-of-state tags. They say that that's reasonable suspicion, and they sort of stack a few things on top of each other that are all basically the same thing. They're like, well, it's an out-of-state tag, and their destination was another state, and so all of those things together give us reasonable suspicion to believe that they've got weed in their car. And the thing about that policy is that the 10th Circuit had already ruled that it was unconstitutional to do that. And they had said in 2016 in an opinion called Vasquez that you can't rely on someone's out-of-state tags to pull them over. And really, you can't even use it in the sort of conglomerate of the totality of the facts to consider, because it's just wholly innocent conduct, and there's no reason to believe that out-of-staters are committing more crimes than in-staters. And that opinion came out in 2016. The legal counsel for the Kansas Highway Patrol looked at it and said, I don't think this is important. I don't think it breaks new ground, and I don't think we need to tell our state troopers about it. And there was a 4-year period from 2016 to 2020, essentially the time that ACLU brought this case, where the Kansas Highway Patrol was just ignoring the Vasquez decision. And so they're stopping all of these cars in violation of binding precedent at a sort of policy level. There were officers who testified at trial that they were trained to do this, and others testified that they were never told they couldn't do this. So it was both the affirmative training and the lack of training on Vasquez that allowed them to make the stops as sort of a policy matter. And then once they did make the stops, they were performing what the court refers to as the Kansas two-step. And so whether they're writing a ticket or a warning, they go up to the car, they finish their business as an officer conducting a traffic stop, and then they sort of pivot and they shimmy, and sometimes they take one step away, sometimes they take 5 steps away, and they turn back around and they say, "Hey, I've got just one more question for you."
It's like
And-
Columbo.
Yeah.
Hey, wait a minute before I go.
Right. And so all of these people they thought that their traffic stop was over. The officer, he doesn't say you're free to go. The officer will say something like, "Have a nice day," or "Safe travels." And then we'll pivot and pivot back and say, "One more question for you." And the people who had this happen to them testified at trial that they did not feel as if they were free to go. There was evidence at trial that in a couple of these instances, for the plaintiff stops, the Kansas two-step took less than 1 second, and so there was basically a 1 second break between the officer finishing the stop in the officer's mind and then re-engaging in this what they're calling a consensual stop. And so that's the two-step. And in to show just like what the people were feeling as they're going through this and whether they had a chance to say no. In one of the instances also, the officers had his arm and his head in their car as he was asking them whether he could ask a question. So like, if you feel free to drive away while there's an police officer hanging inside of your car, is one of the core questions of this case.
I would be thinking I'm going to get shot if I leave at this point.
Yeah, and there are cases that would say that the officer was in reasonable fear for his life and was justified in shooting you. And so the trial, there's this litigation goes on for years. There's trials, there's stipulations, there's concessions. The trial judge hears a lot of testimony and decides there's a policy in place of violating Vasquez. There is also a policy of doing the Kansas two-step, and the Kansas two-step, at least in a lot of iterations, violates the Fourth Amendment because in the trial judge's determination, looking at the evidence, looking at the videotapes, the body cam footage, the testimony of the people who had this happen to, that the officers are carrying out the two-step in a way that would not make people free to leave. And so the judge issues this massive injunction that has lots of components to it that I'll go through pretty quickly, because the scope of the injunction ends up sort of being the thrust of the case on appeal. And so the district court enjoins them from giving any weight to whether a traveler is coming from a drug source state, aka Colorado, or a suspected drug corridor, aka roads leading to Colorado. And they also can't consider whether they are a driver from out of state. And so there's that injunction, and then the court also enjoins the Kansas two-step. And what the court says there is that you can't do this Kansas two-step anymore without voluntary informed consent. And the court wants the consent to be a little more explicit. Let them know that they have a right to leave before you ask them if they're willing to answer any more questions, or get their actual consent and say, like, you could leave, but like, I'd like you to give me your explicit consent, rather than just like, can we tell from the circumstances whether someone would have felt free to leave? Let's make it explicit. And then the injunction was limited to people who drove on 4 different roads in Kansas, because that's where they were doing this. And it would be in effect for 4 years, and Kansas Highway Patrol had to sort of do some self-reporting. The court would check in a couple times a year and make sure that they were adhering to the injunction. And then there were these sort of 6 other series of requirements that there was data collection that would help with the court monitoring whether they were complying with the injunction. Troopers had to affirmatively inform people of their right to leave, like I mentioned, but then the court required Kansas Highway Patrol to record all of their stops so the court could monitor what was going on. Supervisors had to review the tape of the traffic stops within 72 hours to make sure that individual officers were complying. There would be new annual training on reasonable suspicion and voluntary consent, and then these reports to the court. And so it's this huge win. They put together a massive record, went to a few trials, and the judge agrees with them on everything and says, look, Kansas Highway Patrol has been flouting the Constitution and knowingly flouting the Constitution for years, and this program was so widespread. There was an expert that said there were 50,000 additional stops in a 2-year period.
Wow.
That people from out of state were over twice as likely to get pulled over from people in state, that while this Kansas two-step was happening, they were having canines show up, and 90% of the canines sniffs were for people who were from out of state. And so there was all this record that this was a massive, widespread problem, generating a lot of revenue for Kansas, but also violating lots of people's constitutional rights in sometimes small ways, sometimes larger ways, but thousands and thousands of people had their rights violated. It was proven at trial, and the court issues this very aggressive injunction. The case goes up to the 10th Circuit, and the main issues are whether the plaintiffs here have standing in the first place to get an injunction under the case Lyons versus City of Los Angeles, and then whether the injunction itself was appropriate, or at least parts of the injunction were appropriate. And so the court starts with Lyons, and Lyons is this idea that if you want to, it's almost exclusive to Fourth Amendment law, and if you want to stop the cops from violating the Fourth Amendment going forward, you basically need to show that you've been harmed by their policy once and that you're likely to be harmed by it again, or there's a substantial likelihood. And what the court says is, unlike Lyons, who was held in a chokehold by LAPD it was sort of was this part of the policy? And the policy said only use the chokeholds as a last resort. So what the Supreme Court said in Lyons was there's not really a strong likelihood that Lyons can say he's going to get pulled over again, he's going to resist the lawful orders, and the chokehold's going to be the last resort, so we don't really need to get into whether he can stop the chokeholds from happening. And the court in Shaw, the 10th Circuit, says, well, this case is different because there's a very substantial likelihood that you're going to get pulled over. They say traffic stops are routine. It's often beyond the driver's control. They pointed out that for one of these stops, the trooper effectively drove somebody off the side of the road and then used that as the reason to stop them. Some of the stops were for people going 7 miles an hour over the speed limit. So if you can get pulled over and subjected to this policy just for going 5 or 7 miles an hour over the speed limit, there's a pretty strong likelihood that you're going to face this policy again, so long as you're an out-of-stater driving to or from Colorado. And the court says that although there was no formal policy of violating Vasquez and using the two-step, the training sort of let people know that they could do this, and they said that's enough for Lyons because there's a pattern or practice, and so they have standing, they can get this injunction. All 3 judges on the court agree. And then they move on to the injunction itself, and that's where things, I think, get interesting. Judge Federico at this point is writing for the majority of the court, and the first challenge to the injunction is whether it violates federalism. And what Kansas Highway Patrol is saying on appeal is federalism is an equitable consideration that the court is supposed to consider, and by having an injunction against a state entity and requiring them to do certain things, the federal government is interfering with federalism. And they rely on this Supreme Court case called O'Shea, where there had been a pattern of racial charging decisions in criminal cases, and the court entered an injunction that put restrictions on on who could get bond, how courts could sentence people, and and awards of jury fees. And the Supreme Court said you can't do that because of federalism. You're interfering with the state criminal process. The 10th Circuit says, yeah, like we have cases like Younger versus Harris, with Younger abstention. Federal courts are not supposed to interfere with state trials. So O'Shea says one thing, but we're not dealing with federal trials here. We're just dealing with telling the state police that they have to follow the federal constitution. But then there's this second case called Rizzo. And after 2 trials in that case, there was proof that Philly cops were engaging in racist behavior. And the district court in that case required the Philly Police Department to change how they were handling citizen complaints citizen complaints of police misconduct. So it basically put in this injunctive regime to make sure that Philly was taking more seriously citizen complaints of police misconduct. And it goes to the Supreme Court. The Supreme Court says, you know what? The plaintiffs here don't even have standing. And so that's where the holding of that decision ends. And the Supreme Court reverses on standing grounds, but the opinions by Chief Justice Rehnquist. So he goes off on this folly and detour to say, he says, quote, going beyond the considerations concerning the existence of a live controversy in this case, comma, he doesn't think that federal equity power should be extended to the fashioning of prophylactic procedures for state agencies designed to minimize misconduct. So what he's saying, even though there's no standing in this case, I would just like to say that federalism means that federal courts don't have the power to stop state actors prophylactically from violating the Constitution. This would sort of like get at Miranda warnings, stuff like that the court isn't interested, or some justices on the court aren't interested in prophylactic measures to make sure that the states comply with the Constitution. They say, you know what, a declaratory judgment is enough, an admonishment, tell them that they've been behaving badly and they should do better next time, and that should be enough to protect everybody's rights. And the 10th Circuit says, okay, Rizzo's pretty on point, and maybe we can split hairs if we need to about how to distinguish that case. But what we're going to say is we review the granting of the injunction for abuse of discretion, and we don't think that the federalism concerns in this case are so strong that they outweigh the need for the injunction. So we're not going to set aside the injunction on federal grounds under the abuse of discretion standard. And so everyone agrees to this point. There's no standing, or there is standing, there's no Lyons problem, and granting an injunction was fine. And that's where things start to get messy, because Judge Federico loses his majority.
You think he got all that way?
I know. I'm reading. I'm nodding along. I'm like, okay, right. Yeah, good stuff in here. And then you get to like the actual meat of the case, and Judge Hartz takes over, writing the rest for himself and Judge Kelly about the scope of the injunction. And they start by saying that there's no evidence that had KHP trained its state troopers on Vasquez, that it wouldn't have solved the problem. And so they're saying you have all this evidence showing that they just didn't think they needed the training, and that's why all of this continued to happen. But all you had to do was enjoin them to put the training in place, and then we could reasonably believe that they would follow the training. There's no evidence that they wouldn't. They point out that after the plaintiffs filed this lawsuit in 2020, KHP did start training, and there was no evidence that training was ineffective. So they say, the training was good enough. We didn't need to go beyond that. And the majority says, well, federalism lets you do something. You need a really strong showing of necessity. And they say that an emphatic reminder that you're violating the law is enough. And there's that if KHP doesn't listen, you could always bring another lawsuit or go back to the court if it retains jurisdiction and ask for more meat, more force on the injunction. And then they get to the Kansas two-step. and they say, hey, our cases have said that the Kansas two-step is fine in certain contexts. And so the broad injunction here was inappropriate. And they base that on there are some like criminal cases and motions to suppress where trial courts have held that the criminal defendant in that case had given voluntary consent and that the Kansas two-step was fine on the facts of those criminal cases. And the fight then becomes over what's voluntary consent and how do you tell when there's voluntary consent. And the dissent later, Judge Federico, who loses the majority, he says, hey, the trial court listened to a ton of evidence and found, as a factual matter, that the stops here were not consensual, that the drivers did not give their knowing and voluntary consent. And because the test is whether or not, but the majority says it's the Fourth Amendment, so it's a totality of the circumstances test, and whether there's reasonable suspicion or whether there's probable cause, that's a question of law that the court should review de novo and not give any deference to the trial court who heard the evidence. And so that sort of becomes the whole crux of the case is, should the court on appeal decide as a matter of law that there was voluntary consent, or should it defer to the trial judge's findings? And to me, it feels different to say whether there's probable cause or whether there's reasonable suspicion is a question of law versus whether there was actual consent in the case. To me, that feels binary. The driver either consented or they didn't. That should be a factual matter that sort of goes up with the case on appeal, and then the court is just determining, in the absence of consent, was the seizure supported by reasonable suspicion or the search supported by probable cause.
Yeah, it seems like it's almost like the 10th Circuit, that this two-judge majority is saying, when we're talking about an injunction, we can't just look at the facts of this case. And so it almost seems like the reasoning is you can't have an injunction against this practice because it's always going to depend on the facts.
Right. They're saying, like, sure, there are some, and I do think that there's sort of, more honest is probably too harsh of a way to say it, but there's a way to say it in a way that might be more convincing, like you just did, rather than relying on some cases that have allowed the Kansas two-step and then saying, well, we've allowed it in some times, so you can never enjoin it.
Yeah,
and
it's like treating it as a facial challenge, but it's not that.
It's not a facial challenge, and as the dissent points out, the injunction wasn't for all Kansas two-steps, it was for Kansas two-steps without voluntary consent. And so the injunction is just going to this issue of consent, which should be a factual determination, at least in my mind. And so then that would leave it to the trial courts to decide whether or not there's consent, and if there's not, then you violate the injunction. Right. And that seems perfectly workable to me, but the majority sort of shrugs off this idea that you can ever tell when whether someone's given their consent. They say the difference between an officer taking 1 step away or taking 5 steps away, is that really making a difference? If the officer says goodbye instead of have a nice day, does that make a difference? And then they, I think, realize how sort of far afield they're getting, and they say, we do recognize that all of these points are a little abstract, but to your point, they're saying, I guess because the Kansas two-step is allowed sometimes, we then have to allow it all of the time, and that a trial court has no power to enjoin unconstitutional practices.
Nick, curious your thoughts about all this. First, have you ever driven through the state of Kansas?
I have not. I'm sad to say that I am not very well traveled, but the next time I do, I will be sure to try to avoid making it look like I'm coming from Colorado. So
that's a good point.
This was a really interesting case, and I had a couple thoughts as I was reading it, and I would be curious first as a historical question. Do either of you know the origin of the Kansas two-step? And I ask this because there is a Supreme Court case that I'm familiar with from my work here at IJ called Rodriguez versus the United States. And the punchline of Rodriguez is that a law enforcement officer will violate the Fourth Amendment during a traffic stop if he starts doing things beyond the scope of completing the traffic stop. So one could look at the Kansas two-step and say, this could be a clever way to try and get around that. Because on the one hand, the police officer could say, I've completed my traffic stop, and now I'm moving on to something else. So I'm curious if either of you know, was this an attempt to get around, it's not just Rodriguez, there's another case from the Supreme Court from like 2005. I don't know if it's Sabalis or Mendenhall or one of those cases, but similar holding.
I'm sure Jared has the skinny on all of that.
Yeah, I do not know the actual answer, but I'm like reading how the way they set this up and the way they've trained the officers, I am almost certain that it's a response to Rodriguez. We can't extend the stop, so we just need to get consent. You get consent by doing the little shimmy and a shuffle back and then saying, hey, I got one more question for you.
Right. And often during the shimmy itself may be a way to just keep the stop going, but it may be a way to buy time for the car with the canine to get there. So then they can have the dog go around and do whatever it does, and then supposedly have probable cause for the actual search. Like
Yeah.
that's how they often piece it together.
The piece about the canine, too, is interesting because I think that the whole, this case is a really good illustration of why, or of how determining consent is really a challenging thing to do. Police officers can ask for consent to search your car, and then if you deny them consent to search their car, they can then call in a canine, and you are, detained there while you're waiting for the canine to show up before the canine does the perimeter sniff. So it's like, are you really free to go at that point? And is it really non-coercive to if you understand that you're going to have to sit there and wait for the canine anyway? So that was another thing that I was thinking about. It's this area of Fourth Amendment consensual encounters with the police is very messy, and I understand that it's fact intensive, but there is just a lot of doctrinal messiness here that I think the United States Supreme Court should probably wade into at some point.
Yeah, I think what they are trying to, and why I said I think this is designed to get around Rodriguez, is they are trying to draw a clear line of demarcation and say, like, we have not extended the stop at all. We are handing them the ticket. We are saying, drive safely, have a nice day. That is the Rodriguez line. We have not crossed it. Everything that happens is now in a separate category. And as long as we get voluntary consent, we can extend the stop. We can extend the stop long enough for the canine to come, and we can do any investigative steps we want to as long as there's consent. And I think that's why so much of this it's super interesting to me and shows how hard it is to litigate these Fourth Amendment cases, given the record that the ACLU built and how they showed that there was not voluntary consent in the instances of all their plaintiffs. And you get up to the court and there's this big fight over standard of review, which is like typically taken as a pretty boilerplate boring thing where everybody just sort of like tacks it on to before the argument in their brief. But it's doing all of the work here is whether or not you're going to give deference to the fact finder on whether there's been voluntary consent.
And I'll just say one last note to one of the things Jared just said is that as I was reading the case, it was apparent to me that the architects of this case really had their ducks in a row. I mean, they worked hard to make sure that their factual record was very strong, that they were prepared for the inevitable argument over Lyons, and having done a little bit of similar work here at IJ, my hat is off to them because it's clear that they took a very organized approach to this case and they came prepared.
Yeah, the plaintiffs in this case are the ideal what you'd want for the challenge. They were stopped, right? They didn't get arrested and go to jail, but their rights clearly were violated, and so the case all comes down to this kind of the fourth step out of all the steps you can have with judicial restraint, which is, well, how can we not have to do an injunction here? That's going to be really complicated.
And one thing that I glossed over that I wanted to get to, there were a couple good points in the dissent about this federal question and federalism question, and like the power that federal courts have to stop state actors from violating the Constitution. And he's like to me like that's like what the Civil War and the Civil War amendments were about, and all of those are pretty open and closed questions. And I know like this whether federalism is in vogue with which party switches sometimes from presidency to presidency, but if their federal courts don't have a mechanism to make state bodies follow the Constitution, then there's not much point left to the Constitution. And the dissent points out here that one thing that makes the federalism concerns particularly inapt is the fact that Kansas is targeting out-of-state drivers engaged in interstate travel. And so, like, the rights of our federalism, as the Supreme Court has said, like our collective federalism, means you should be able to drive from state to state without being mistreated because of what state is on your license plate tags.
It's a really good point. That's kind of the apotheosis of federalism, and the reason for the federal government is traveling between the states.
Yeah.
Well, we're going to turn from the Fourth Amendment to the Second Amendment in a different context than we're used to, and that's out in California in the Ninth Circuit. And so, Nick, tell us the story of switchblades and whether you can ban them.
Absolutely. All right. So my case is called Knife Rights Incorporated versus Bonta.
That's a great name for your organization in a case like
It
this.
is. It is. Knife Rights is basically a nonprofit organization who seeks to, advocate for the ability to keep and bear bladed arms under the Second Amendment. So, Knife Rights Inc. and two retailers of bladed weapons brought a facial challenge to portions of the California Penal Code, which ban the possession, sale, transfer, and carry of switchblade knives. This was a unanimous opinion by a three-judge panel of the Ninth Circuit. It was written by Judge Wardlaw and joined by Judge Gould and Co. And so one of the things that I think is interesting about this case, the facts of this case are far simpler than Jared's case. So what I thought I might do is give a little bit of context for the Second Amendment, particularly in the Ninth Circuit. And then, if we have time, go through the case, but then also talk about some of the things that were not directly discussed in the case, which I actually think this opinion is probably most interesting for the things it does not discuss versus the things it does discuss. So here, California, like I just mentioned, maintains a couple different provisions of its penal code, which severely restrict what you can do with switchblade knives. And as a starting point, some listeners may justifiably be wondering, well, why are we talking about knives? Isn't the Second Amendment about guns? And this is just kind of a friendly reminder that the Second Amendment refers to arms, which in Heller, the Supreme Court explained are weapons of offense or armor of defense, and that the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. And since Heller, a couple of courts have recognized different sorts of arms that are protected under the Second Amendment. And since today is our Second Circuit episode, if memory serves, there is a case out of the Second Circuit somewhere that said that nunchucks are a protected arm under the Second Amendment.
That's right. I was hoping you'd bring that up. Yeah, the nunchucks case.
There are other courts that have recognized that knives are protected under the Second Amendment, and the Supreme Court itself has recognized that stun guns are protected under the Second Amendment. So this is not really some sort of brave new world that we find ourselves in talking about non-firearm arms. And so the other thing we may want to define in the beginning is a switchblade knife, because that might be a little ambiguous to some listeners. And so California defines a switchblade knife as a knife having the appearance of a pocket knife and includes a spring blade knife, snap blade knife, gravity knife, or any other similar type knife, the blade or blades of which are 2 or more inches in length and which can be released automatically by flick of a button, pressure on the handle, flip of the wrist, or other mechanical device, or is released by the weight of the blade or any type of mechanism whatsoever. So, listeners, if you close your eyes right now and envision a pocket knife and take that same pocket knife and give it sort of a spring-loaded mechanism which engages the blade and brings it from the folded position to the fully extended position, you now have a switchblade knife, and that's what is covered by...
And 2 inches long or more.
Correct.
So it's like a bump stock for knives.
Kind of, yeah. That's an interesting comparison. And so the court begins its analysis by saying that primitive switchblades go all the way back to at least the 18th century, but the ones we know and familiar with now are fairly new, and they come around shortly after World War II. And so under Bruin and Rahimi, I assume that most of our listeners will be familiar with the tests that we use now for the Second Amendment. So I won't spend too much time rehashing Bruin and Rahimi, other than to say that the test is the text, history, and tradition test. So we focus now on whether or not a state can produce a historical analog to the type of law that's being challenged. And if the historical analog is consistent with our nation's history and tradition of regulations of firearms or other kinds of arms, that's what the state would need to show to demonstrate that the law is constitutional. And the Bruin test has its detractors and its defenders, and there's a lively kind of scholarly debate going on about that right now. But one thing that I thought might be important for the listeners to know is that ever since Heller was decided in 2008, the Ninth Circuit has not been an especially hospitable place to bring Second Amendment challenges. Judge Lawrence Van Dyke of the Ninth Circuit generated some controversy in the last couple of years when he pointed out in a dissent that with an almost perfect record, every time a three-judge panel in the Ninth Circuit has found that a law violates the Second Amendment, that panel decision has been vacated and reversed by the en banc Ninth Circuit. And en banc review, as listeners probably know, is fairly rare. And so part of Judge Van Dyke's point is that this is something that the federal appellate courts engage in infrequently, and yet every time there's been a finding that a law violates the Second Amendment, that three-judge panel decision has been reversed en banc.
And I should jump in here and say we did one of those rare birds a few months ago, and I frankly haven't tracked it for our Where Are They Now series, and I don't know if it's gone en banc or not, but I would not be surprised if it has or it's about to.
And so the court spends time. So the court, as I said, opens by noticing that the kind of modern switchblade knife is fairly new. It comes around after World War II, and the court states that there was an apparent uptick in the use of switchblades in criminal activity starting around the 1950s, and that's when states and the federal government got in the business of regulating them. So the court then provides us with a little summary of Bruin and Rahimi, laying out kind of the different aspects of the Bruin test. And the Ninth Circuit says that it is going to assume, without deciding that, switchblade knives fall within the ambit of the Second Amendment, and then proceeds to the historical analog portion of the test. And when reasoning by analogy, as Bruin describes, the Supreme Court explained that there's really two questions that courts should ask. How does the law being challenged burden the right, and why? And if this, how and why is sufficiently analogous to other laws that the state can produce from our nation's history and tradition, then the law being challenged could survive constitutional challenge. And so the Ninth Circuit says that if you look back through the history of regulations of Bowie knives and other kinds of knives like this, and I'll explain a Bowie knife in a second, but things like the Bowie knife, the Arkansas toothpick, daggers and dirks, sword canes, and slungshots.
Sounds like a Dungeons and Dragons campaign.
It really does. It really does. And so there's these categories of weapons that states regulated, most notably by prohibiting concealed carry of these types of weapons. And so the court concludes that because states were regulating these types of knives and slingshots, which, for those who don't know, a slingshot is a piece of rope with kind of like a weighted ball at the end of the rope. And it was used for a couple different things, but most notably, if you were to kind of sneak up on somebody and hit them over the head with it, that could do some damage at close range.
It stays attached, like it's not like a slingshot.
Correct.
It's like a tetherball court that you swing at someone.
I didn't have the opportunity to look up like a good picture of it before sitting down to record this podcast, which I probably should have. But I would imagine the effect would be much the same as if listeners recall, a couple of years ago there was a video of a guy at a protest who snuck up on somebody else and hit that person in the head with a sock that contained a lock inside of the sock.
Yeah.
Similar kind of effect.
It kind of looks like a dog chew toy, like a ball on the end of a rope. Okay, I get it.
I think there's a different name for like the medieval weapon style of that, but
With like the spiky ball on it.
yeah.
Isn't that a mace?
Well, mace has a like a handle that's
right.
Yeah, but there's one with like a rope, a heavy thing on the end of a rope. Anyway, we have a colleague who is really into medieval martial arts, who is probably going to listen to this and shake his head at all of us. But anyway, we'll do our best to continue.
So the panel looks and says that there is this tradition based on the practice of several states of prohibiting concealed carry of these types of weapons. And the purported why, so the how was you may not carry these types of weapons in a concealed manner. And the purported why is that these knives were used in fights and duels and were known to be fighting knives or intended for interpersonal combat. And as a result, in an effort to curb the crime problem, you could not carry these weapons concealed. And so the Ninth Circuit says that is, although switchblades are not exactly the same thing, that is a close enough analog to justify upholding this California ban. Or I'm sorry, the California regulation, because the question of whether or not this is truly a ban, I think, is one of those things that I want to talk about. That's notable for not really being discussed in the opinion to the extent it probably should have been, or we may have wished it was. But first, to circle back to Bowie knives, like what is a Bowie knife? So I found this definition courtesy of Dave Kopel. So in full disclosure to the audience, Dave Kopel does a lot of Second Amendment scholarship.
And he's been on Short Circuit. We had him on a few years
He's been on Short Circuit, and I believe if he did not author a brief in support of the challengers here, his work gets cited by them. So I just want the audience listening to be aware of that. But he says that the term Bowie knife originated after frontiersman Colonel Jim Bowie used one at a famous quote-unquote sandbar fight on the lower Mississippi River near Natchez, Mississippi in September of 1827. And this knife had been made by his brother, and the knife was intended for hunting. The length of the knife was about 9 1/4 inches long, with a width of 1.5 inches. It was single-edged, and its blade was not curved. And Dave Kopel notes that nothing about that was sort of unusual for the time. This resembles a hunting knife that you would have found in kind of all over the continental United States at that time. So the Arkansas toothpick is kind of another similar rendition of this Bowie knife, but it was just more common in places like in Arkansas. Finally, a dagger is a straight knife with 2 cutting edges and a handguard, and a dirk was originally a Scottish fighting knife with 1 cutting edge. And then other things that get swept up into these historical regulations are sword canes, which is exactly what it sounds like, a walking cane that concealed a sword. And then the slingshot, which we've already talked about as being the sort of rope with a heavy metal or some other kind of heavy ball at the end, which you could use to strike someone. And so what's interesting, I think, and feel free to jump in as you guys have thoughts, but there were a few things that I thought were particularly interesting about this opinion. The first is that when you look at the provisions of California law that were being challenged, the court spends most of its time discussing the restrictions on your ability to carry a switchblade knife concealed on your person out and about. But there's another portion of the California Penal Code which says that such knives have to be surrendered. And so, without doing a comprehensive look at the Penal Code, you could just look at the portions that are cited in this opinion and think, well, it's a little ambiguous as to whether or not this is just a restriction on just carrying the knives, or if they are in fact banned outright. And that's kind of important, I think, for the rest of the analysis, because the laws that the Ninth Circuit relies on to identify the history and tradition of regulation here are all laws that prohibited concealed carry of these knives, but did not make the knives illegal. And as a matter of fact, there was one state, Georgia, that had a statute which banned the Bowie knife, and that statute was subsequently found unconstitutional under the Second Amendment by the Georgia High Court. And that is a detail that gets left out. I think it gets left out of the three-judge opinion here, but if you go poking around in the amicus briefs that were filed in this case, that is some information that you will discover.
Can I ask a question
Sure.
about that? I obviously understand the distinction between concealed carry and not, but when we're talking about a knife here, and if the law is just forcing you to not conceal it, is the point of that law just so people know not to get in a fight with that person because he's got a big knife on him? Like what's the concealed versus not accomplishing? Like, what's the government's interest?
So, my understanding, and Anthony, I wouldn't be surprised if your historical research sheds a little bit more light on this, but as I recall, there was some discussion in Bruin, and then there was also a law review article that I'm aware of that talks about how carrying a weapon of some kind in a concealed manner back at the time of the founding was sort of a dishonorable practice. It was, viewed as being the kind of thing that criminals would do, and that the kind of upstanding citizen would not do. And if memory serves, Bruin dedicates a portion of the opinion to say, the norm of concealed versus open carry has evolved since the time of the founding. However, we wouldn't understand that to completely neuter the right to bear arms in public.
Yeah, that's. I think you basically nailed it there, Nick. Is that in a society such as the founding, where a lot of people did carry arms, whether it be a sword or a knife or your firearm, that you would carry it openly. It was, it wasn't shocking to see that. To carry it in a more concealed manner was seen as a little bit more unusual. So that's why you might ban the concealing, and it's just kind of common knowledge that there are going to be people walking around with it open.
So it's almost like they're linking concealment with, like, you're probably going to do a crime. Like, it's almost like prophylactic.
Yeah, I don't know if it's probably going to
like
do a crime,
morality.
but it's that you're kind of outside the norm.
Interesting.
And so why would you want to conceal it, right? We just
Yeah.
know people they're walking around with arms.
Yeah, and it's interesting because, like, I understand the history and tradition test, but that's also, like, we have a tradition then of, like, regulating almost like nobility or morality around the weapon, and that seems like a weird government interest to, like,
it does
endure.
I mean, I think it's a really good point, Nick. I mean, it's pretty obvious too. It is quite a stretch from that kind of law to an outright ban, and saying, well, it's just part of our history and tradition. I mean, it almost stretches credulity.
And one other thing that I think would be kind of interesting to bring into the conversation is that here the three-judge panel of the Ninth Circuit affirms the district court, but for different reasons. And since we had no dissent in this case, I thought it was worthwhile to check out the amicus briefs just to see kind of what the other side was arguing. And in the district court, the judge upholds the California regulation by concluding that switchblade knives are not commonly used for self-defense and are dangerous and unusual. And this is significant because Bruin explicitly says this sort of analysis is not appropriate anymore. Before Bruin, there was a pattern in the lower courts where lower courts introduced this sort of threshold test, like is the thing in question that's being regulated or banned actually an arm under the Second Amendment? And if they could conclude no, or if it wasn't an arm, or if it wasn't in common use, then the court didn't have to engage in the historical analysis and sort of do the hard work to figure out whether or not the Second Amendment, appropriately covers these things. Even after Bruin, the briefs of the Second Amendment Foundation and the National Rifle Association point out that there are some courts that have kind of reintroduced this sort of threshold step, which the district court apparently did here. And those briefs spend a lot of time talking about how considerations about what is in common use and what's dangerous and unusual belongs in the historical portion of a court's analysis under Bruin. This idea about whether or not the Second Amendment is even implicated is, according to Bruin, supposed to be a rather low threshold inquiry. So if you're dealing with something that is a bearable arm, the Second Amendment is implicated, and we are on to history and tradition, where at that point you talk about what's in the common use and whether or not a particular weapon or arm is dangerous and unusual. And the Ninth Circuit settles on upholding the California laws on the basis of the history and tradition test, but it doesn't spend a lot of time talking about why the district court was wrong to do what it did, which I think is kind of interesting, because the amicus briefs point out that the Ninth Circuit apparently has actually blessed this sort of threshold inquiry before we go on to history and tradition. And so there's arguably a little bit of tension within Ninth Circuit case law on this, even post-Bruin. Yeah. And so for anyone who thinks that, this might be a trivial question about knives and whether or not they belong under the Second Amendment, there's kind of a more rigorous methodological point to be made in this case as well, that the amici were very, kind of eager to point out. And if we are looking at, if the California law is in fact a ban on the possession of switchblade knives, then the government is on weaker footing, because sure, you can regulate the ways in which one could carry switchblade knives. There's a prohibition on being able to carry them concealed in our history and tradition, but an outright ban would be much harder to defend under the history and tradition test.
Well, I suspect with all the intransigence you might call with the Ninth Circuit and even after Rahimi and the Second Amendment, and with the pending cases at the Supreme Court about the Second Amendment, where we'll get some more data, and we don't need to go into those today, but listeners can find them and probably know a bit about them. Also, there's the one about having drugs and the Second Amendment. We're going to get some more tea leaves at the low point, or explicit instructions at the high point from the Supreme Court. And I think a lot of these Ninth Circuit cases they're going to have to come up with a new way to deny Second Amendment rights in the Ninth Circuit than the way they've been doing it recently. But we are running long on time. But I would thank you, Nick, for that great description of that case, and I encourage people to watch it, and we will continue to watch it here. But before we close, a little bit on the Second Circuit, which we did not cover today. Now, if people want a deep dive into the Second Circuit, they can go find a show we did a few years ago, which was called Live from New York, It's Short Circuit, which was all about the Second Circuit. So that's Short Circuit 243. It was a Short Circuit live we did in Manhattan a few years ago, which was really close, I think, to the Second Circuit courthouse, which is, by the way, from what I can tell, is the only courthouse where they regularly hold argument. And you will hear from three former Second Circuit clerks who were part of that panel that Patrick Giacomo hosted. So we'll put a link up to that in the show notes. But kind of the general information about the Second Circuit is it is, again, the states of New York, Connecticut, and Vermont. So it's not big state-wise, but of course there's a fair amount of population there. It has 13 authorized seats, and they are all currently, as we record this, full of judges, although there's 14 senior judges. So they get a fair amount of work there in the Second Circuit, and of a fairly big docket. It is the circuit justice is Justice Sotomayor, which is appropriate, and a few other things about the Second Circuit. Their practice, they are kind of notorious for very rarely going en banc. They think, stick with the panel. I think that's slowly changing as the circuit makeup is a little more ideologically diversified. It's not exactly overwhelmingly one side of the judicial ideology than the other, but it has been a little bit for a number of years. In their opinions, I appreciate they use Palatino font, which a couple circuits use, so they don't just go with Times New Roman or the Courier we talked about in the First Circuit. And IJ, over the years, our track record in the Second Circuit, we've been there a few times, not the greatest. Now, we had this epic case called Brody that my colleagues Dana Berliner and near the end of it, Bob McNamara, when he was first starting at IJ, litigated. And it was a property rights case where our client was just treated atrociously, taking of his property to build a port. And it was improvement by a port, and so there were procedural due process, property rights, all this stuff. They had to go up and down the Second Circuit, I think 3 times. Anyway, we had a little bit of success at that case. Some cases not as much success. We had a property rights case just recently. Our friend Jeff Redfern argued that at first didn't go so well. We got 3 votes for cert at the U.S. Supreme Court, but that's not enough. You need 4. And then the district judge amazingly awarded fees to the other side for even bringing the case in the first place. We went to the Second Circuit and was like, come on. And anyway, that had a happy ending where the Second Circuit said, no, we're not justified to award fees against the plaintiffs in this case for trying to defend their property rights. So that's another tale of the Second Circuit and IJ. We won't go on about the others. And either of you have special Second Circuit thoughts?
It's inhospitable. I have never felt warm or invited there with my legal arguments or my team's legal arguments. I only have maybe 5 anecdotal experiences to go off of, but it feels pretty statist. Like it doesn't even matter who's in power, the government is likely to win, is my general sense of it. And like I'm always told that it's tied up and like, well, it's the banking center of the world, and so like they have a different perspective on government regulation, but it seems to just sort of reach every form of government regulation, no matter who's in party and what they're doing to regulate it. I've just never in the 5 cases that I have worked on that have been there, none of them have ever like felt like they got a real grappling with the constitutional issue there, except for what was a Judge Menashe's dissent in Redfern's case.
That's right, the first time up. Yeah, that was we like that dissent. So
but,
well, I don't think Jared's bitter. I think he's taking a measured approach from experience, but maybe we will have happier times in the future in the Second Circuit. But overall, yes, it because it's the Second Circuit, and it's New York. It has cases, a lot of cases in the banking sector. A lot of admiralty law cases go through the Second Circuit. Years ago, I did a little admiralty law, and either the Second Circuit or the Fifth Circuit, it seemed, was most of the case law. Well, so that's the Second Circuit. Look forward in the future, dear listeners, to other circuits as we go through the circuits and months in 2026. But for now, we'll leave it there in Manhattan at the courthouse. And I'd like to thank my colleagues here for their tales of Kansas and California. And Till next time, please be sure to follow Short Circuit on YouTube, Apple Podcasts, Spotify, and all other podcast platforms. And remember to get engaged.
Keep your nunchucks on you in the Second Circuit.